Everybody, and welcome to Alan History Nerd. This is another video in my series on A-level and US politics. In this particular video, I am looking at the protection of civil liberties and rights in the US today. So this is a really important video. It's about a lot of the stuff that's been going on throughout American history, going all the way back to the Constitution itself, and then the Bill of Rights, and then a series of amendments since. And I'm also trying to make this kind of really up to date by looking at Supreme Court, a load of Supreme Court judgments, a lot of which are fairly recent. And all this fitting together kind of underlines the rights that US citizens have. This is part of the EDEXCEL A-level specification. It's in component 3A and it is part 4.4, the protection of civil liberties and the rights in the US today. The rights protection by the Constitution, by the Bill of Rights, by subsequent constitutional amendments and the rulings of the Supreme Court. It tells us you need to know. So I'm going to be quite helpful, hopefully, and I'm going to go through that, all those different bits, and to try and give you a decent understanding of a whole series of court decisions and bits of the Constitution and various amendments. And hopefully they'll give you loads of really good examples if you're required to write an essay on this particular topic. So to start off with, we need to look at the two key definitions of civil liberties and civil rights. So civil liberties are basic rights and freedoms often ensured by democracies through law. So these are the kind of the real fundamental freedoms that you would hope and expect to have, and obviously some absolute key ones that are underlined in the US. So they include things like the freedom of speech, the freedom of movement, freedom from arbitrary arrest, freedom of assembly, freedom of association, and freedom of religious worship. So lots of the key freedoms that we would expect to find in a liberal democracy like the US. Now, civil rights is slightly different, but very, very closely related. So civil rights guarantees equal social opportunities and protections under law, regardless of race, religion, sexual orientation, or other personal characteristics. So essentially, civil rights is about protecting the civil liberties of the people, and the certain groups are not excluded from those civil liberties because of those kind of protected characteristics, race, religion, sexual orientation, or any other personal characteristics that might be brought in under that. So they're two really important things to have in mind when we're looking at this. And again, if you're writing an essay on this kind of area, they're two key terms you'd have to make sure that you defined and show that you fully understood what they were. So we're going to start with the Bill of Rights now, and we'll start at the beginning. We'll start with the First Amendment. So there are a couple of really key bits with the First Amendment. One of them is it protects freedom of speech and all forms of expression. Now, this is something that obviously it is constantly evolving and needing a degree of new interpretation as all forms of expression change through history. But they can include things like protest, individual expression, organisations expressing views, the freedom of the press, and then obviously in the more modern day we kind of then move on to things like the internet and things like that. So there have been some important Supreme Court judgments on this amendment. They include Citizens United versus FEC 2010, which essentially reversed the regulations on money spent by organisations in elections. And another one, if we go back a bit further, is Texas versus Johnson 1989, which established flag burning as a protected right under the amendment. And under the First Amendment, there have been a series of flag burning amendments that have been proposed to try and overturn this. And that's a really good illustration to show that actually, if you've got a combination of something that's in the Constitution and an interpretation established by the Supreme Court, really the only way around that, if you dislike it, is to amend the Constitution, which is a difficult procedure in the US. Another key freedom in the First Amendment is freedom of religion. So this protects people from religious discrimination and prevents official religion being established in the US. So in the UK, we have the Church of England established state religion, and in the US, they're worried that if you have that, then other forms, other religious groups and organisations could be discriminated against. A key Supreme Court case on this is Engel versus Vitale, which prohibits the government written prayers or state written prayers in public schools. So again, the prayers in schools is a big issue in the States, and the kind of legality of it and the things, and that is really saying that if essentially if a state or federal government produces a prayer, you cannot read it in public school. But this is still an area of ongoing debate, and I think soon we might see further action in the future. Now, there's a whole series of court cases been on this. I just picked out one others, which is just to kind of show that you can't do a government written prayer in schools. But according to interpretation of the Constitution, going to the Supreme Court case in 1993, the court found that a Florida law that prohibited animal sacrifice in religious rituals was unconstitutional. So there are restrictions on prayers in schools, but there aren't on animal sacrifice. So there we are. But again, an important part of the freedoms in America and in many countries is the freedom of religion. Right, now this is the one where I just have to claim a kind of a cultural kind of block, I think. So the Second Amendment, the right to bear arms, is obviously enormously important to a lot of Americans, and is very hotly debated and argued about. And it is one of the things that us Brits have a tendency to look across the pond and go, well, I don't get it. So I will, again, so in America this is really, really important. It might seem very strange to myself and other people in Britain that it is such a key issue, but it is. So it gives the right to bear arms. Now, they seem to be linked in the initial writing of the Constitution in the Second Amendment in the ability of states to raise a militia and defend themselves in case the British turned up, or the French or someone, and decided to try and take over, and so it would give the idea of defending the states and the nation. Now, there's a couple of really important Supreme Court judgments about this, which are fairly recent. So D.C. versus Heller in 2008 overturned a Washington D.C. ban on handguns in the home and requirements that rifles and shotguns be kept unloaded and disassembled. All of that was deemed to be unconstitutional, and it was a 5-4 victory, so it was very close, again with a conservative liberal split on the justices' bench. And what was really significant about it is it seems to set up this idea that one of the reasons you can legitimately constitutionally own a gun is for self-defense. Those who objected said that this is not actually reading the Constitution its original meaning. So Stephen Souter, Ginsburg and Breyer argued against this, argued that the Second Amendment only covered the raising of militia. That judgment of 2008 was further reinforced with McDonald versus the City of Chicago, and it said that state governments can restrict gun ownership, citing the 14th Amendment, which we'll look at some aspects of the 14th Amendment a bit later in the video, as well as the Second Amendment. So there had been a citywide gun ban on handguns in the City of Chicago. McDonald, who was a retired gentleman who in his 70s, who wanted to own a handgun for self-defense because his property had been burgled and his garage had been broken into on a number of occasions, so he wanted a handgun for self-defense, and under the city law he couldn't have one, and this was deemed again to be unconstitutional, and again reinforcing the idea of being able to own a handgun for self-defense. And so we've got this deeply kind of enshrined now in constitutional law, as going all the way back to the Second Amendment, but also reinforce this idea of owning a gun for self-defense by the judgments of McDonald versus City of Chicago and DC versus Heller. So this right is something that you'll see a lot of Americans protesting in favour of, but you will also see a degree in America where people are kind of worried about this complete freedom to own guns and the social and damage that can do. So the Fourth and Fifth Amendments are also really important. These are to do essentially with justice systems. So the Fourth Amendment gives people freedom from unreasonable searches and seizures. Warrants are needed to search private property, and police require probable cause. And so again, if you watch any kind of cop drama or crime and law and order type thing in the States, you'll always say that they're waiting for the warrant and have you got a warrant and all that kind of stuff. And so that's an important part of the Constitution, going back to the Fourth Amendment. In terms of some recent stuff, in 2014, Riley versus California, extended this to mobile phones. So you actually need a warrant to go into someone's phone because of all the kind of information that could be had in that, and it made it like a locked cabinet rather than like having a wallet in your pocket. And so again, that was quite significantly. There's interesting that there was a requirement in the Patriot Act of 2001 that kind of removed the probable cause clause for some cases again, and that's not been overturned in the Supreme Court. So interesting again, and it shows how things in terms of constitution could depend to a degree on circumstances, as these are very much the kind of thing with the advent of the mobile phones, the phone with all your personal details and things on it, and also with the threat of terrorism in the US. The Fifth Amendment, and you might often hear in cop shows and things about people pleading the Fifth, which gives them the right to remain silent. There are also other things in the Fifth Amendment, such as the idea of double jeopardy, where you can't be tried for the same crime twice. And again, there's been some films and stuff made about some cases around that. Probably the most important Supreme Court case surrounding the Fifth Amendment is the Miranda versus Arizona case in 1966. That led to the reading of Miranda rights on arrest, and again, you'll hear those being read out if you watch a cop show on someone getting arrested. You've also got Burgess versus Tompkins in 2010, and this is seen to have eroded the degree in which the insistence on people being aware of their rights. So what happens with this one is if law and order forces can reasonably assume that the accused is aware of their rights, they can proceed and you maybe use stuff that's used against somebody, even if they haven't overtly either invoked or waived their rights. So they might say, I waive my right and I want to say this, or they might invoke the Fifth and say, I'm not saying anything. Well, they've not specifically done either of those things. That can be kind of perceived now as consent, that they understand what's going on and they will. You can use what they've said against them. This fell on a 5-4 decision. It angered a lot of liberal judges like Sotomayor, and again was seen as an erosion of some of the defendants' rights. The Bill of Rights, another key element of it is the Eighth Amendment. Well, the Eighth Amendment is to do with cruel and unusual punishment. I find this would be quite mind-blowing stuff, because the argument about it is really around what cruel and unusual mean. Again, they are in the original amendment, they are fairly vague, and so what the Eighth Amendment has become the focus of is it's become the centre of debates over capital punishment. So capital punishment in the US is not currently considered to be cruel or unusual in terms of interpretation by the Supreme Court. Now, it has been in the past. There was the Furman versus Georgia Act as judgment in '72, which deemed that existing laws allowing the death penalty were cruel and unusual. And a lot of that was actually to do with the technicalities of how it was done, rather than saying actually murdering, carrying capital punishment and killing people is wrong. It was kind of like, well, actually, there's some prejudicial things in the way that these are done, and there's some inconsistency in the way that these things are done, and there needs to be some central guidelines. So you need to go away and think about these laws again. And various states did, and Grege versus Georgia in '76 is seen as reinstating the death penalty by laying down guidelines on sentencing and a certain criteria that need to be met. And there have been various cases where different states' law guidelines on this have either been upheld as meeting this standard or knocked down because they don't. The most significant recent challenge to the idea of the death penalty was in 2015 with Glossip versus Gross, and there's a 5-4 ruling that death by lethal injection is still not considered to be a cruel and unusual punishment, and therefore stands. Lots of states are no longer using it, but it is still constitutionally legal to do so. So again, a very fundamental right in the states, and a really important part of the justice system in the states, which goes back to the Bill of Rights. The 10th Amendment is maybe a little bit different to the others in terms of rights, because it's not looking at individual rights, which all the other ones we've been talking about have been, but it's to do with the rights of the states. So the 10th Amendment is essential in protecting federalism in the US, in ensuring that the power of the federal government is restricted. Now, any powers not explicitly given to federal government fall to state governments, according to the 10th Amendment. This can, however, conflict with Article 1, Section 8, known as either the necessary or the elastic clause, which allows Congress to make all laws which shall be necessary and proper for carrying into execution the foregoing powers. Right, so Congress seems to have this very elastic thing that allows it to pretty much decide what it does and doesn't have jurisdiction over and what it can and cannot make laws over. But the 10th Amendment very strictly seems to be saying actually anything that hasn't been explicitly given to you, Congress, by the Constitution actually falls to the states. Now, this has been used in a variety of different ways over time, and it is again an ongoing debate and conflict in American politics. Printz versus US in '97 protected states I mean, they didn't have to create gun restrictions following the Brady Act of '93, which had instigated background checks into those buying handguns. Now, actually, most states have kept the Brady Act, but the Printz versus US meant that this is a federal law, it's not a state law, so the states don't have to go and start making laws restricting the buying of handguns. Again, it was a 5-4 split. It was a conservative liberal split based on support of the 10th Amendment versus support of Article 1, Section 8. So again, another way we can divvy our court up and our justices up is often conservative justices will fall in line with the 10th, and the more liberal justices are more likely to fall in line with Article 1, Section 8. So another area of constitutional debate in the states. The 14th Amendment, I think, is arguably the most significant of the amendments post the Bill of Rights. Now, it's set up in the post-Civil War era during a period known as Reconstruction, and its aim was to prevent racial discrimination and to ensure that the newly freed slaves had citizenships right. And there's a whole lot more stuff in there as well in terms of how it's played out. So the history of it is really significant. So you have the 3 civil rights amendments: the 13th, the 14th, and the 15th. The 13th Amendment ends slavery. The 14th Amendment guarantees citizens' right and protection against racial discrimination, and the 15th is mainly to protect the right of the newly freed to vote. So really important history to it. Now, it has then been one of the amendments that has seen the most kind of legal action and significant parts to it. It gives citizenship to everyone born or naturalized in the USA. So if you are born on US soil, you are an American citizen. And it also guaranteed all citizens full and equal protection under the law, and that has had a great deal of significance over time as well. Now, it's not without its controversy. Quite clearly, Trump very consistently argued against the birthright citizenship clause, but it remains in place. Again, it would take an amendment to overturn that, and it's difficult to see that ever having the numbers to go through. There is also a clear suggestion in the 14th Amendment, and this is due to the fact that it was an amendment that followed the Civil War, that no leading member of the executive or a member of Congress shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. So essentially, if you are involved in insurrection against the US government, you are in breach of the 14th Amendment, and so this could be used essentially to remove you from office and offer sanction. There has been some suggestion in the US that this could be used to act against members of Congress who were seen to be supporting the insurrection. So, for example, the likes of Mo Brooks, who spoke at the rally, and Josh Hawley, who was seen as perpetrating and spreading the claims that had been made by Trump and Ted Cruz as well. Whether anything will come of this, I'm not sure, but it is, again, it's an interesting thing in terms of showing the 14th Amendment as something that has a real impact in American politics as they're unfolding at the moment. There are a whole series of really, really significant Supreme Court cases involving the 14th Amendment, particularly to do with things like race. So probably the most significant Supreme Court case of the 20th century is Brown versus the Board of Education, which outlawed segregation on the basis of race, arguing that the separate was never equal. We also have Loving versus Virginia in 1967, which deemed a Virginian law banning interracial marriage as being unconstitutional. Now, it has moved beyond just being used against the idea of racial discrimination. So Obergefell versus Hodges in 2015 it led to a constitutional guarantee of the right to gay marriage, forcing many changes in state policy. It was only legal in 36 of the 50 states at that point. Right, and then the whole bit with racial discrimination has become more complex as time has gone on. So initially, what the 14th Amendment was done was to protect the rights of minorities from overt discrimination. Now, some of the more recent cases are to do with what is known as affirmative action. So affirmative action is when institutions or governments try and redress imbalances that are historical. So if there is underrepresentation within a company or an educational institution on race, and therefore they might bring in quotas or other affirmative action to try and readdress that balance. These have been highly controversial. The examples of it we see is the Regents of the University of California. This is back in 1978. And this ruled that racial quotas or affirmative action were unconstitutional where race was the only factor. So Back had been denied entry into university, and that was because he argued was because of the quota system. So some people who were not as well qualified as him got in, but they got in because of the affirmative action, because they weren't white, but he was white, and so he didn't get in. So he argued he was being discriminated against because he was white. We see another case in 2003, Gratz versus Bollinger, which further clarified this need for an individualized approach, that the affirmative action couldn't be a straight kind of, we will have a quota of X number of people of this race, and therefore exclude people who were not of that race from a limited range of positions. Now, we've seen this as an ongoing issue in the legal system and in the Supreme Court. So there's a pair of cases in 2007 that deemed the use of racial quotas in schools as unconstitutional. So we've got Parents Involved in Community Schools Incorporated versus Seattle School District, and Meredith v. Jefferson County Board of Education, which is in Kentucky. So we've got one in Washington State and we've got one in Kentucky. The first one in Washington is based in Seattle schools, and what the Seattle School Board was trying to do was it was trying to prevent or stop having the situation where it had white schools and black schools. Now, the way that the housing patterns worked in Seattle and where the schools were located meant that if they did nothing, essentially you would have had white suburban schools and black inner city schools, and the school board wanted to avoid that. So it used a quota system to try and level out and have integrated schools. Now, the court turned around and said, well, whilst they might have good intentions, then that does, but they were still essentially allocating positions on race, and that was unconstitutional. And it's a highly controversial issue, and the Conservatives in the court kind of accused the school board of essentially trying to do a degree of social engineering, and therefore cast it down as being unconstitutional. Another recent case has been Fisher versus the University of Texas. There's two versions of this, one in 2013 and one in 2016, kind of a follow-up appeal. And it rolled around Fisher failing to get a place at the University of Texas, whilst less well-qualified students from ethnic minorities did. And part of this was down to, it wasn't a straight racial quota, which had already been deemed unconstitutional. It was about a point system which was allocated, and students from ethnic minorities automatically got, I think it was 20 points allocated to them. Now, the university was told to essentially to go back and look at its procedures again in the first one, and then the second one actually upheld what the university was doing in pursuit of diversity. And so again, we've possibly got a lack of complete clarity on affirmative action, but essentially what it seems to be is that if you do it solely on race, it's unconstitutional. If there is an individualized approach which looks at a whole range of factors, then it's okay. And again, I'm sure this is something which might well come back to the Supreme Court in some form or other as we go forward. The 15th and 19th Amendments are really important in terms of voting acts or voting rights. So the 15th Amendment was, again, one of the Civil War amendments that was aimed to protect the right to vote and stop people stopping you from voting on the basis of race. Now, there's a rather unpleasant history in terms of ways a lot of the southern states tried to get around this, including poll taxes, literacy tests, and then a various series of other unfair tests to determine whether somebody had the intellect to vote, which were very heavily biased against black people in those states. Probably most infamously, there was the grandfather clause that was instigated by some states, which insisted your grandfather had to have voted in that state for you to be able to vote. And because when it was instituted, essentially, it prevented the vote of almost all black people in some of those southern states. When the civil rights movement took hold, and there were attempts to kind of re-establish the 15th Amendment, really, which had been badly kind of got round, there was the Voting Rights Act of 1965. This was reauthorised for the 25 years in 2006 by George W. Bush. But the Shelby County versus Holder case, it was seen by many to be removing protection of minority rights, and following it there was a series of laws introduced in southern states that would have been blocked if that Supreme Court judgment hadn't taken place. Because in that there was a formula that required certain states to get a pre-approval from federal government before they changed any voting laws. So again, a highly controversial one where again, arguably, the Supreme Court was removing rights rather than supporting them in terms of the rights of minority groups. Again, that isn't the only interpretation of that, and obviously the fact that it passed shows that the majority view was different to that on what it meant. We also have the 19th Amendment, which gave women the right to vote, and it was then upheld by Lesser versus Garner in 1922. So there's a series of rights that aren't necessarily explicitly mentioned in the Constitution or the Bill of Rights or any other amendments, but have been established as rights by the Supreme Court and its rulings. Now, the first of these really important areas is the one of abortion. Now, the absolute key case on this is Roe versus Wade of 1973. Now, that uses the 14th Amendment, including the right to liberty, and included in this freedom of personal choice in matters of marriage and family life. And it therefore included in its in judgment the idea that a woman's right to decide whether or not to terminate her pregnancy was protected by that 14th Amendment. It was a 7-2 judgment, and it is seen as one of the biggest landmark cases, again, of the 20th century, of the Supreme Court history. It is a hotly debated issue in the States. Abortion is a really big political issue there. Again, something which it isn't really in the UK. One of the more recent cases, again, which is seen as a bit of a landmark one, is Gonzalez versus Carhart of 2007. This upheld a ban on what is known as Partial Birth Abortion Ban Act from 2003. Now, this act banned a very specific type of abortion. The judgment upheld that ban, and the judgment was based on the way that the fetus was treated in that particular procedure, and not on anything to do with the rights of the woman or risk to the woman involved. Now, there is a concern amongst liberals that this is going to lead to a chipping away at the right to abortion as established by Roe versus Wade, and has given those who dislike Roe versus Wade judgment a different route into attacking it. That rather than having to get Roe versus Wade overturned, that essentially they can chip away a type of abortion by type of abortion, as has happened with Gonzalez versus Carhart. So we can see maybe a shift in the court can lead to a shift in the way that this is going to be interpreted going forward. In terms of LGBTQ rights, then we've seen some of this already. So the Obergefell versus Hodges 2015 gave the constitutional right to gay marriage, forcing states to change their policy where they hadn't already legalized it. And then we've also seen Bostock versus Clayton County in 2020 that gave the employment protection given in the 1964 Civil Rights Act to people based on gender identity and sexual orientation as well. So the Supreme Court has played a really key role in the promotion of LGBTQ rights in recent times, and then historically in the promotion of women's rights in terms of an abortion. Where the one on abortion will go next, I think, is something that people will be watching with a great deal of interest, and I'm sure there will be ongoing controversy over in the US. Thank you very much for watching. I hope you found that helpful. I know that it's a slightly longer video and it is full, but it should be jam-packed full of loads of really good examples that you can use to illustrate a whole range of different points about how well rights are protected in the US, and the role the Supreme Court has in that, and the role that the Constitution has in that, and the Bill of Rights, and then other amendments. So there should be loads of stuff that's really helpful to you, I hope. If it has been, then please hit the like button. If you have any questions or comments, then please leave those below. If you're interested in US politics, if you're doing A-level politics, or you've got interest in just a general interest in these areas, then please subscribe, as I will be adding more and more videos on these topics as time goes on. I'm aiming to cover the whole of the A-level specification as I teach it, we will you also see on my channel there's a whole range of history playlists as well, looking at various bits of UK, US and European history. Thank you very much for watching. Goodbye.